Hi, everyone. I hope you had a good week and welcome to this week's episode of Law Chats with John and Amy. I'm John Yulian.
I'm Amy Poliaco. This week's question is, are gambling debts dischargeable in a bankruptcy?
Well, that's a very timely question, Amy, now that we have sports betting, the casinos betting in Massachusetts. It's clearly become a lot more prevalent here in Massachusetts. And as I say, the sports betting is fairly recent, but you can see the gambling debts will be a bigger issue as time goes on. And to your question, the issue of are they dischargeable in a bankruptcy? So I'm going to start with a general premise, which is gambling debts are unsecured debts, like a credit card debt, line of credit. Those are unsecured debts, and those are normally dischargeable debts. So, for example, someone files a Chapter 7, those debts will be discharged. But the problem is you really have to put an asterisk by that comment. You have to understand that there are exceptions to the norm or the general rule. Obviously, that's one of the things with the law. People want like a nice black and white answer. And unfortunately, all too often, it's not that black and white. So this is a perfect example of that situation. So, Amy, maybe you can touch on sort of these exceptions to the rule or why it isn't, many times going to be dischargeable, even though the general rule would be, yes, it's an unsecured debt and it's dischargeable.
Yeah, so sometimes it's not an unsecured debt. Sometimes you put up collateral when you're taking out a loan and using that money for gambling. You're putting up a car or a secured bank account. And in that case, the debt is secured. And so although your obligation on the debt may be discharged in a bankruptcy, the debt is still attached to your car. So there's still a note on your car, even if you're no longer personally liable for it because you got the bankruptcy discharge. Another way that comes up is if someone takes money out of their home equity line and then uses that to gamble. Because you've now increased your home equity line from $50,000 to $75,000. That is still debt that is owed on your house. And you're not going to get rid of that in a traditional bankruptcy way. You're going to have to repay it. Another thing is if you're taking out debt on some kind of open credit within 70 days of filing your bankruptcy, that depending on the amount that you take out could also not be dischargeable. So you can't just like go from Encore Casino and then go file that day. That's likely not going to be dischargeable. So John, you want to talk about how it goes from your filing it to it becomes non-dischargeable, or who parties are involved and how that happens?
Sure. So if we talk about a Chapter 7 bankruptcy and someone's looking to discharge their what we call unsecured debt, which is credit cards, hospital bills, personal loans. If you don't recall this, feel free to watch one of our prior podcasts where we've discussed it. But if you have gambling debts in there, or it could be to a casino or various other means which led to the gambling debts, those can be challenged by the trustee. The Chapter 7 trustee who oversees your case can raise the issue. The office that oversees the individual trustees is called the U.S. Trustee's Office. The U.S. Trustee's Office can look into matters where there's possibly this gambling debt or an unusual amount of high incursion of debt, maybe in a relatively short period of time or over an extended period of time for someone who allegedly has limited income. And it also can be looked into by the creditor itself. So if someone ran up this tremendous line of credit on a particular credit card or with a particular company, it could be the casino itself, they certainly have a basis to look into it. And not that the gambling debt itself is a problem, but there could be underlying aspects that cause the fraud. On the application, did the person misrepresent what their income was, what their assets were, et cetera, which obviously leads to a problem. But those are the normal parties that could raise these issues and then argue this debt is non-dischargeable. And then it will have to play itself out through various hearings and so forth.
So it's important to be upfront so that your attorney can address that and properly advise you to see if bankruptcy is the right option for you to handle your debt.
Thanks, Amy. I think that's a great point to stop for today. And
Yeah, thanks for joining on the chat with John and Amy. We look forward to chatting with you again next time.
If you have a question or comment, feel free to email us at info@ulianlaw.com. Remember that Law Chats with John and Amy is intended as a general reference and considered general advertising, and listeners should check for changes to any applicable laws and consult with an attorney on any legal issue. The information provided does not constitute legal advice, and any thoughts or commentary by the podcasting lawyers is provided as a service to the community and does not constitute solicitation of legal advice. The lawyers in the law firm of Julian & Associates PC make no warranties and disclaim all liabilities for damages resulting from its use. Nothing provided in the podcast should be considered a substitute for advice from counsel. No attorney-client relationship is formed by listening or participating in this podcast, and in the event that the podcast receives emails about the subject matter, no attorney-client relationship is created via the email communication.
And I think that we have seen in our cases, the U.S. trustees is going to get involved where it's someone who has maybe a fixed or a lower income and has accrued a large amount of debt in a small amount of time. Those are just red flag cases, and they're going to start looking into it.